Okay, yeah, so let's talk about that a little bit.
Yes. So you want me to just pick up from what you were just talking about?
So yeah. So is this in North Carolina, is this legal for HOAs to have an exit fee or something like this?
The answer to the question is no, it's not legal in North Carolina. For a while, it was legal to have what's called a transfer fee, meaning a fee that your homeowners association would charge if you sold your home. At the transaction table, usually the seller would be required to pay either a fixed monetary amount or a percentage as what's called a transfer fee. And as you might imagine, people got quite angry and there was a hue and cry in North Carolina around 2010 over homeowners associations and condo associations charging these fees on transactions. And of course, people argued that it was going to make it difficult or more difficult to sell a home if you had to then incur a 2% fee on top of the other transaction costs and that sort of thing. And that it would decrease the marketability of homes in Charlotte and North Carolina. And so the legislature passed a specific statute. It's in chapter 39A, and it's North Carolina General Statute 39A-1, and then there's a couple of other paragraphs, and it's entitled, as you can see, Transfer Fee Covenants Prohibited. And the very first sentence of it says that the public policy of the state favors the marketability of real property. We want to be able to sell our homes and realize our gains. And so part of this statute was designed to facilitate that. And then the legislature recognized the problem that a transfer fee covenant, meaning when you buy into a neighborhood that has an association or a condominium that has an association, everyone needs to be aware that the declarations that are filed down at the courthouse at the Register of Deeds that are part of your deed and the covenants and declarations of the association are all part of your agreement when you buy the home, and you're bound by those things. So it underscores the importance of hiring an attorney or having someone review the documents and reviewing your transactional documents yourself to see if this type of a fee is in these documents. Now, the legislature, as of 2010, for condominium associations, homeowners associations that are formed after 2010, file their documents at the courthouse after 2010. From 2010 through right now, these types of transfer fees are not legal. There are some exceptions, of course, and the statute goes through and says that any type of transfer fee covenant, like the one we're describing, violates public policy because it impairs the marketability of title and constitutes an unreasonable restraint on alienation and transferability of party. Alienation just means I own it, I sell it, now you own it. And then they carve out or exclude a number of types of other fees to make sure that people don't get other fees like a real estate brokerage fee or a fee that might get charged to transfer the homeowner's paperwork over. It makes sure that, and it's clear that it only applies to the type of fee really that you're describing, where there's a real estate transaction, the homeowners association exacts, let's say, a percentage or a fixed amount against that transaction, and then you have to pay it. So long as the covenants or the promises to do this, the filings down at the courthouse for your association occurred after 2010, you're protected by the legislature through this particular statute, and that is in North Carolina. Now, these transfer fee covenant prohibitions, like we have in our North Carolina law, they're also found in many other states. So for a person that lives in South Carolina, just right over the border, you'll want to Google whether or not there's a transfer fee covenant prohibition, and you will find out pretty quickly. And if there is, then you can take this in to whomever, to your association, and present it to them, and hopefully they'll see what the law is and they'll follow it. And then otherwise, on the front end of a transaction, you're going to want to make sure before you buy or sell real estate in North Carolina that you do read the documents, and if you can, to have an attorney review them, because inside of all of this paperwork, we've all been at real estate closings and the paperwork's a foot tall, and you think to yourself, well, Gary, the lawyer, is telling me to read all these documents. It's impossible to read thousands of them. An attorney knows what he or she is looking for in those documents and knows what to beware of. And it's part of the aid of having a real estate attorney, a qualified real estate attorney, help you with your transaction, whether you're the seller or you're the buyer. And these types of fees and whether they exist and could be charged against you are one good example of why an attorney is really helpful and why you should be looking at the documents, even if they are a foot tall. At least look at them, see what they are, and then ask questions when you're at the closing table.
And you're saying too, like so 2010, so if you signed in 2008, you would be on the hook for this fee in North Carolina.
Well, it's based on not really when you signed, but like in my neighborhood, there's an association. And so when the neighborhood was being constructed, the developer, they have a plat drawn, surveyors and that sort of thing. And then they go down to the courthouse and they record documents, meaning declarations, the rules of your association. Can't park a car in your driveway,
Sure.
Or can't have renters and that sort of thing. Those documents are filed at the courthouse, at least some of them. And then others you sign on to, whether you know it or not, when you move into a neighborhood or a condominium that has an association. It's part of your overall purchase of the property and the rules that go along with that. And so if the filings for your association, more or less, if your homeowners association was founded or created after July 1 of 2010, then under North Carolina law, you're going to have the protection of this statute. If you've been living somewhere for a long time, or you're in an older established neighborhood and it was created before July 1 of 2010, then you're really going to need to look out, because you would not have the protection of this statute. The statute also goes on to say that if there are other defenses to the agreement that you might have, let's say you were defrauded into the agreement that contains this transfer fee provision, that would be another legal defense to it, although that would be harder, more expensive, and more difficult to apply for sure than being able to show up with the person, the association that's attempting to charge you and say, hey, you were not formed until after 2010, and I believe there's a North Carolina statute that protects me here. And you would want to show up with that, and then hopefully the person would recognize it, that they were outside the law if that were the case, and remove it from your transactional fees.
Okay, because I just want to get that straight from my own self. That so if an HOA was created, a neighborhood HOA in 2002, they can still do these transfer fees, correct?
Yes, that is correct.
Thank you. That's all I wanted to make sure.
And if your neighborhood was, let's just say, in all likelihood, if your neighborhood was built after, July 1 of 2010 or thereafter, then you're probably protected by this statute, because typically one of the first things that happens is the developer, the people that are building your home, your property, your condominium, are going to have these things done by surveyors and by lawyers and architects and that sort of thing. And they're going to go down to the courthouse. They're going to file them. They're going to make them part of the transaction. When you buy the property, there will be a diagram in your documents that shows what you bought. And when they're filing all of that stuff at the courthouse with the Register of Deeds, that's the date that you're looking for. So pretty much, if your neighborhood was constructed after July 1 of 2010, in all likelihood, you're protected by the statute. If it's an older neighborhood, older than 2010, then probably you're not protected by this statute. And I'm sorry. And you're in all likelihood, you'll be subject to whatever fee that was agreed upon at the closing table in those transactions.
Okay, good to know. And then, okay, and then I'll have to look at South Carolina, because you don't know that off the top of your head, do you?
I can look real fast when we get off the phone, or let me see right now.
I made one call in
So, okay, so it appears that in 2012, the state of South Carolina, and I'm looking at it, passed a statute of their own, which in many respects appears to mirror the North Carolina statute. And it is at section 27-1-70 of the South Carolina Code of Laws. I'm not a South Carolina attorney. I need to underscore that. But I do frequently look at other states' law, you know, as part of my practice. And so this appears to be a, without any, you know, any more research than we've done right here, a law that parallels the law that we have in North Carolina. And it was effective February 1 of 2012. And I'll send it to you when we get off the phone or off of Zoom.
Awesome. Awesome. Yeah, that's good to know. I'm sure like a lot of states probably, right, created this, you know, probably after around that time. So
yes.
Cool.
And it almost reads, although they kind of looks like what's at the top of ours is kind of at the bottom of theirs, but it almost appears to read word for word on our statute. So what happens is a lot of times there will be smart people that know how to draft the law, and they will draft these templates for legislatures to use. And it appears that they probably used the same template in most states. So just in South Carolina, you're going to hope to be in a neighborhood that was created on or after February 1 of 2012, as opposed to North Carolina, where we're talking about July 1 of 2010.
Okay, cool.
But again, this underscores, I see this a lot. I see clients who enter into transactions, whether they're securities transactions or real estate transactions, and they're unfamiliar with the transactions. They're not lawyers. And what'll happen is they'll get into these deals, and then when they try and get out, they find out that, hey, I can't get out of this deal as easy as I thought I could, or there are these onerous fees that make it very difficult or expensive and unprofitable for me to get out. And so all of these are good reasons for folks that are entering into a big transaction, a car, a home, some type of retirement investment, to always review the material. And if you can afford it, this is why it's good to have a lawyer. And in every single case, you need to be asking, what happens when it's time to wrap up or close or sell this particular thing that I have bought? Can I get out of this transaction? Can I get out without paying exorbitant exit fees? And am I allowed to even sell whatever it is that I'm buying? These are not foregone conclusions. And what I find is that people enter into these transactions and they want to get out. Timeshare is another good example. They want to get out. They find themselves trapped. And they would not have been trapped if on the front end, they had someone like me sit down with them and go over the documents and say, here's what this means. Can you live with it? Do you understand that this provision is there? And the reason to have your own attorney is, more often than not in a business transaction, the person or company on the other side does not owe you a disclosure duty. That means it's not up to them to go over your documents and explain every single provision in them. And if there's something in there that you don't understand, that's on you in many, many circumstances. It's different if they're trying to fool you or flim-flam you, but just sitting down in a business transaction, the person across the table from you does not typically owe you a fiduciary transaction. And all of this underscores why it's very helpful to have a lawyer, pay a lawyer $250 or $500 or some nominal amount, so that when the time comes for you to sell your property, you're not facing these restrictions and these huge fees that might get assessed otherwise.
Yeah, 1000%.
We are good for something.
Yeah, exactly. Exactly. You do.
Regardless of what Shakespeare says.
Exactly.
Right? Round them all up.
Well, thank you so much. Good luck
You're
with
welcome.
today. We're all
Thank
thinking
you
about
so
you
much.
over here. So
Cool.
yeah, and have fun this weekend.
Thank you so much. It's good to
Yeah,
see you.
good to see you. Bye. Bye.
Cool. Okay, bye-bye.
Bye.